Equal protection of laws. Concept of the equal protection of laws. All persons or things similarly situated must be similarly treated both as to rights conferred and responsibilities imposed. Similar subjects, in other words, should not be treated differently so as to give undue favor to some and unjustly discriminate against another. From the case of Ichong versus Hernandez, Equal Protection Clause does not require the universal application of the laws on all persons or things without distinction. What the clause requires is equality among equals as determined according to a valid classification. By classification is meant the grouping of persons or things similar to each other in certain particulars and different from all others in these same particulars, from the case of the Philippine Judicial Association versus Prado. Scope of equal protection of laws. Natural and juridical persons. The Equal Protection Clause extends to artificial persons only insofar as their property is concerned. A corporation, as an artificial person, is protected under the Bill of Rights against denial of due process, and it enjoys equal protection of the law from the case of Smith, Bell & Co. versus Natividad. B. A corporation is also protected against unreasonable searches and seizures from the case of Stonehill versus Diokno. C. It can only be proceeded against by due process of law and is protected against unlawful discrimination from the case of Bash and Corporation versus Ruiz. What are the requisites for a valid classification? 1. It must rest on substantial distinctions which makes for real differences. 2. It must be germane to the purpose of the law. 3. It must not only be limited to existing conditions. And 4. It must apply to all members of the same class. Presumption of validity. All classifications made by law are generally presumed to be valid unless shown otherwise by the petitioner, from the case of Lacson versus Executive Secretary. Rule on aliens. General rule. A legislative act may not validly classify citizens of the state on the basis of their origin, race, or parentage. Exceptions. A. In times of great and imminent danger, such as threatened invasion or war, such classification is permitted by the Constitution when the facts so warrant, that is, for example, discriminatory legislation against Japanese citizens during World War II. B. Political rights of aliens do not enjoy the same protection as that of citizens. C. Statutes may validly limit to citizens exclusively the enjoyment of rights or privileges connected with the public domain, the public works, or the natural resources of the state. The rights and interests of the state in these things are not simply political but also proprietary in nature. So the citizens may lawfully be. What are the levels of scrutiny? In Serrano versus Gallant Maritime, it introduced a modification in equal protection jurisprudence by using 3-level review used in due process cases. In effect, the level of review when it comes to equal protection challenges may follow the following format. A. For rational basis test. Rational basis test is the classification should bear a reasonable relation to the government's purpose or legitimate state interest. Take note that this test is important when there is no possible difference between the disadvantaged class and those not disadvantaged, and when the government attaches a morally irrelevant and negative significance to a difference between the advantaged and the disadvantaged. 2, or B, another level of scrutiny is intermediate scrutiny test. In intermediate scrutiny test, the court accepts the articulated purpose of the legislation, but it closely scrutinizes the relationship between the classification and the purpose based on a spectrum of standards by gauging the extent to which constitutionally guaranteed rights depend upon the affected individual interest. Government must show that the challenge classification serves an important state interest and that the classification is at least substantially related to serving that interest, applicable to certain sensitive but not suspect classes, certain important but not fundamental interests. And lastly is the strict scrutiny test as the third level of scrutiny. For example, in Central Bank Employees Association versus PSP, the challenge proviso operates on the basis of the salary grade or officer-employee status, it is akin to a distinction based on economic class and status, with the higher grades as recipients of a benefit specifically withheld from the lower grades. The officers of the BSP now receive higher compensation packages that are competitive with the industry, while the poorer, lower salaried employees are limited to the rates prescribed in the SSL. The implications are quite disturbing. BSP rank and file employees are paid strictly regimental rates of the SSL, while employees in higher rank, possessing the higher and better education and opportunities for career development, are given higher compensation packages to entice them to stay. Considering that majority, if not all, the rank and file employees consist of people whose status and rank in life are less and limited, especially in terms of job marketability, it is they and not the officers who are the real economic and financial need for the adjustment, This is in accordance with the policy of the Constitution to free the people from poverty, provide adequate social services, extend them to a decent standard of living, and improve the quality of life for all. Any act of the Congress that runs counter to this constitutional desideratum deserves strict scrutiny by this court before it can pass under the muster. Again, from the case of Central Bank Employees Association versus BSP. In upholding the constitutionality of an ordinance imposing curfew upon minors in Quezon City, the Supreme Court resorted to the strict scrutiny test and ruled that under our legal system's own recognition of a minor's inherent lack of full rational capacity and balancing the same against the state's compelling interest to promote juvenile safety and prevent juvenile crime, it finds that the curfew imposed is reasonably justified and its narrowly drawn exceptions and hence not constitutionally infirm. From the case of Spark versus Quezon City. Suspect classes. A classification that violates a fundamental right or prejudices a person accorded special protection by the Constitution, from the case of Serrano versus Gallant, may therefore include a classification based on income. The test is usually applied to cases involving classification based on race, national origin, religion, lineage, denial of the right to vote, migration, access to courts, and other rights recognized as fundamental. Levels of classification or examples of valid classification. From the case of Philippine Association of Service Exporters versus the Relon, Philippine female domestic workers working abroad. They are a class by themselves because of the special risk to which their class was exposed. From the case of Conference of Maritime Manning Agencies versus PUEA, land-based versus sea-based Filipino overseas workers, there is similarity or dissimilarity as to work environment, safety, danger to life and limb, and accessibility to social, civil, and spiritual activities. Another case from Almonte versus Velasquez, Office of the Ombudsman, allowing the Ombudsman to start an investigation based on an anonymous letter does not violate the Equal Protection Clause. The Office of the Ombudsman is different from other investigatory and prosecutory agencies of the government because those subject to its jurisdiction are public officials who, through official pressure and influence, can quash, delay, or dismiss the investigations against them.